File number 22-93215FH for sentencing. I have received a letter from Sable Valley CMH and from Go Team Services on behalf of the defendant that I have reviewed. And Mr. Piper, have you had a chance to review the pre-sentence report with your client?
I have, Your Honor.
Any additions or corrections to that report?
It is factually accurate, Your Honor. I have some comments to make during elocution, but nothing that needs to be added to this.
Okay, and the advisory guidelines were scored at 0 to 17. Any scoring challenges or no?
No, Your Honor.
Mr. Radsabon, any additions, corrections, or scoring challenges?
No additions or corrections, Judge, and I believe it's scored appropriately.
All right, Mr. Piper, go ahead.
Judge, this represents Mr. Latrell's first felony conviction. I went over the report with him. He understands what the recommendation is and the reasons for the recommendation. He would, however, like the court to consider whether we're placing him on probation and not incarcerate him immediately. This case occurred coming up on 2 years ago. I believe it was early July of 2022. Without getting into any arguments that appear to address guilt or innocence, I don't want to mislead the court or send the wrong message to the court. So we're not arguing about that. But the initial 911 call that came in reported Mr. Latrell engaging in some odd behavior, including crawling around on the grass, making comments about his daughter being kidnapped. And so certainly things that would lead a reasonable person to believe that he was suffering from some mental illness. Now, with that being said, he was also highly intoxicated, and we don't challenge that in any way, shape, or form. He admits to that. He understands that. He's been working on his sobriety since this occurred, so we're not arguing that he wasn't under the influence as well. But the request was really in the nature of getting him some help, more so than it was getting law enforcement involved because of any criminal activity that he engaged in at that time. It did result in a violent encounter with the police. We certainly understand that the court takes those things seriously, so we don't mean to minimize what occurred. There was some body cam footage of it as well. And when the body cam starts, you see Mr. Latrell ordering the officers off the property. Officers obviously said it doesn't work that way. When he refused to follow their lawful command, specifically to get on the ground. That's what resulted in the confrontation with the police. He was physically assaulted with them. He did obstruct. He did resist. He freely admits that. Judge, subsequent to that, once he posted bond, he himself admitted him. Went to Point East initially. He walked into Point East in Alpena. Admitted himself psychiatrically, ended up transferred to the psychiatric unit up at War Memorial Hospital in the Sioux. Stayed there for a period of time. He got back on his medication. The report indicates that he suffers from mental illness. He's been suffering from mental illness for a long time. Obviously, the result of not being on medication and also being under the influence, I think, caused him to behave in the way that he did. We did have him evaluated by the forensic center. They said he was criminally responsible. Once again, we're not challenging that finding. But I think in fairness to Mr. Latrell, it's not as simple as him simply being drunk and wanting to engage in some physical confrontation with the police. I think he was suffering mentally at the time. He has been seeing a therapist at El Sabo Valley Community Mental Health for a while. The court has a letter there. It sounds like from the therapist that the last psychotic episode he had was when this occurred. He's been on bond for a substantial period of time and has followed the court's bond conditions. He does have gainful employment as laid out in the letter. He is working a little bit more than full-time right now, a little over 40 hours, although he anticipates that as the summer goes by, those hours will increase. He's done his best to put his life back together since this occurred. He physically looks better today to me than when I first had contact with him. So it appears to me that he's probably sober and probably staying on his medication as directed. He's just hoping that you would consider something other than incarcerating him for the period of time recommended. He's also asking if the court would fashion some sentence that might give him the opportunity to maintain his employment that would be difficult. Even if he had work release from here, I don't think that would be possible. The only possibility to maybe do that if the court does want some type of incarceration or something held over his head is if the court would consider some type of tether or house arrest. But he would not be able to, wouldn't be able to travel from here to his employment. It's too far away. And I'm not sure that the sheriff would allow that to occur anyways, even if there was work release available. By way of the fines and costs, Judge, he's expecting a check from his employer tomorrow. He can pay all of those tomorrow. He intends to do so. He did lay out in the report that he really doesn't have a real good memory of what actually happened here, but he certainly doesn't challenge what the officers say happened. Accepts responsibility for it. I'm not sure if he'll be able to communicate to you right now. He's pretty nervous and pretty scared about what might happen. So I just ask that the court consider those comments in addition to the letters that we provided the court.
Thank you. Mr. Latrell, you don't have to tell me anything today. If you don't, I don't hold that against you. But you may make any statement to me you wish. Is there anything you want to say, sir?
I just appreciate any considerations and thank you for your time.
How willing are you to take care of this Indiana outstanding warrant?
I could take care of it as soon as I have this taken care of.
Well, I mean, you've been able to take care of that since 2017.
Yeah,
You failed to appear.
I did run from it. I admit to that. But
If I even consider putting you on probation conditions, you got to travel to Indiana and physically own up to that warrant. If they put you in jail, they put you in jail.
okay,
You're willing to do that.
I would be willing to do that.
Mr. Radsbot, any recommendations from people?
Judge, first of all, we agree with the recommendations of the department. And I think even with the recommendation for jail, some period of probation, I think, is important to follow up and make sure he is continuing with his mental health treatment and his medication, and B, remaining sober. Judge, had he been following his medication regimen, we might not even be here today. If he had not compounded that mistake by then consuming alcohol to the point of intoxication without taking his medication, we probably wouldn't be here today. But the bottom line is he did both, and as a result put 4 officers at risk, got into a heck of a tussle with the 4 officers, tried to spit on them. We can't have our officers subject to that, Judge, so some consequences is appropriate. They recommended 9 months. I guess I would leave that up to the court's discretion, but I don't think that's inappropriate. It's about the middle of the guidelines. And insofar as any lingering issues in Indiana, yes, he'll have to take care of it, but I think he should take care of what I believe is his obligation to the law enforcement here by serving some time in jail and with some probation on top of that.
Well, Mr. Latrell, this is, not a complicated charge. Resisting obstructing police is a fairly complicated charge. It's a 2-year felony. The guidelines are 0 to 17 months. We see these types of cases a lot, and they're on a sliding scale of how, any failure to comply with a lawful command of a police officer is resisting obstructing that officer. Doesn't even require an assault, and here you were physically aggressive with them, threatening with them. So the charge itself is not that complicated. The facts of you are what makes this much more complicated. I mean, the police are called to respond to some behavior that was at least partly driven by mental health concerns. But the prosecutor is exactly right. I mean, if you were following your treatment regimen and were sober and nonetheless had some mental break, I think courts would bend over backwards to try to find a way to work with that and to solve that problem. But the prosecutor is absolutely right. You decided to stop taking your medicine. You decided to also get drunk. You're responsible for that behavior. You've got a prior R&O on your record. You've been on probation in the past, and you haven't done well with that. You have a charge for drunk driving in the state of Indiana that you fled from 7 years ago. And they have a statewide pickup outstanding warrant. And for 7 years, you've just been thumbing your nose at the court in Indiana. So you're aggressive and threatening to the police. You don't do well on probation in the past. You're thumbing your nose at a court system as we stand here today. And then you come here and you want us to help you. But what makes it tough is it's very tempting to do so. I mean, I've got some good letters from your employer. This was a couple of years ago. You've gotten back on your treatment, you know, and you're engaged, you're working. You know, I'm hesitant to kind of upset the apple cart with those things. I really am. But man, it's just really, really tough to go out of my way here for somebody who's going out of his way to avoid justice. You've been going out of your way for 7 years to avoid justice for a serious charge, driving under the influence with a high BAC. The people of Indiana have the right to have justice on that charge. I don't know if you're guilty of it or not, but they've got the right to have that charge go forward. And you're an absconder from justice on that charge. So I don't know. I don't think putting you on probation is a great idea. So there's fines and costs of $130, crime victims assessment $68, state costs $350, and court costs, and I'm going to order you to serve 6 months incarceration in the Prescott County Jail with credit for 4 days previously served. That is a sentence within the advisory guidelines. It's not an intermediate sanction. I'm giving incarceration because of the prior poor supervision on the outstanding warrant and the prior R&O. Mr. Latrell, that's the sentence of the court. Will be served forthwith. If you wanted to appeal, you have to file an application with the Court of Appeals. If you want a lawyer, you have to ask me for one within 42 days. We're going to ask you to initial one copy so that we have a record we gave it to you, and the other one is for you to fill out if you wish to take an appeal. Good luck to you, Mr. Latrell.